agricultural tourism to add and amend definitions and types of use for major and minor agricultural tourism activities and set forth specific regulations for each. Reference Communication 554, introduced by Ms. Willie, postponed November 17th and December 1st.
I'm glad that some items from my earlier wish list made it onto the bill. I submitted testimony listing the stuff that I still would like to see in the bill. Regarding approval, I'd like to see approval required for both major and minor ag tourism and for ag products processing facilities. I'd like to see site inspection required to get a permit. And if a permit is not approved in 30 days, it should be automatically denied. For health and safety, operators should try to see that visitors don't go trespassing on neighbors' land or wandering over there. And animals should be kept safely and humanely and adequately confined. For roads, it would be good to have road signs to direct visitors so people aren't driving around always asking the neighbors, where is this place? And the main thing is the neighbor impacts. There should be ag tourism only 8 hours a day. There shouldn't be exceptions like in the current bill. Only 5 days a week. And as the song says, never on a Sunday. So you used to get a day off, the neighbors. No more than 200 visitors a week. Facilities not over 1,000 square feet. And the property size and number of operations per neighborhood should be limited so neighborhoods don't get overwhelmed. And the operation should fit in with the character of the neighborhood. No like House of Cards or strange or these, European mansions in rural neighborhoods. If someone's going to do ag tourism, they should inform the neighbors ahead of time when they start applying for approval. And the noise from ag tourism should not go beyond the property line.
You have 30
Police have
seconds.
said that loud noise is allowed on ag land day or night, even if it's not from agriculture activity. So you move out to this nice quiet place and then wonder what all this racket is. Some council members are concerned about enforcement in remote areas, but that can be handled by having permit fees and fines that are sufficient to fund enforcement. Property values for ag tourism properties should be based on facilities used for ag tourism, but the property taxes for neighbors should not go up. So, thank you.
This issue came up 3-4 years ago with agritourism, and Waipio has remained steadfast that we need to get a handle on this very dangerous situation of traffic coming into Waipio on the very dangerous Waipio access road. Case in point, this past holiday season, we were seeing 200-300 people a day walking into the valley with a lot of traffic, Jeeps, rental cars, tour vehicles, and it's a dangerous situation. Somebody's going to get hurt, and we need to get a handle on this. And so Waipio wants to share, and already does share, just by growing taro, by providing poi, by providing educational opportunities, but we need to get a handle on this. And any attempt to increase traffic into the valley is not only irresponsible, but dangerous. I sit as vice president of Ha'ulo Waipio Valley, a community group whose mission is to take care of Malama Waipio for the future generations, to perpetuate our culture, perpetuate farming and its agricultural roots, and also a member of Waipio Valley Stakeholders Alliance, which is an alliance of the various groups that make up all the perspectives of Waipio. And we talked about this, especially this loophole that's contained in Communication 554.5 that does allow agritourism to increase into Waipio with a loophole that says if the Planning Commission supports it, then it's okay. But again, we're steadfast. And again, we don't want to shut off Waipio. We don't want to exclude anybody. But Waipio needs to share on Waipio terms, and we have to get a handle on this. Our community groups are working very hard on coming up with a long-range plan for Waipio so that we can share, but do so in a way that is pono and correct for Waipio and for our future generations. Again, so what I would ask is that you exempt Waipio from this agro-tourism bill, say, no more agro-tourism in Waipio, strike that loophole.
I am in agreement with this guy from Waipio because my family is from Waipio, and I have gone down to Waipio from when I was little, when we used to ride horses down there. And I took care of my uncle who left Waipio when he was 102 years old, and he died when he was 106. So I know Waipio Valley. I know going down there, and you know, people have gone down there. This is a place where we work, where we lived. And you have tourists and all these other people coming down and just dirtying the beaches, all kinds of stuff.
In terms of our county, our current rule, we do allow ag tourism at the moment, but it's basically for large-scale operations. Would have a minimum of 10,000 in gross sales and goes on. So what we're trying to do, as I see what the intent here, not just from me, but from Councilmember Kern and all of those that have worked on this before, is to try to provide a way that smaller, in particular, that small farms or family farms or not large-scale operations are able to obtain a permit and integrate tourism with their operations. So if you turn to communication 554-5, the first question I would ask is, okay, what approvals do you need? And I think Ms. Harding sort of brought that up, that the original should every proposed ag tourism operation have to come in and get a plan approval? What I have here, and which was partly from in the past, would be that plan approval would be required for all major agricultural tourism operations. And in the case of minor, which means like you're under 5,000 visitors a year, that you would have to, if there's any construction involved. But for a farm stand, that we not require, and that you can put up your own farm stand and not have to have approval. So I'm trying to minimize the bureaucracy that's involved, but at the same time not be where we're, are we allowing something where we're really allowing a harm to surrounding farms or individuals. But what I did add basically in response to Ms. Harding and to others who have spoke last time is that all ag tourism operations would register. If you were to look at my bill, this would be on page 6 under the conditions for ag use. And an ag tourism operation shall register with the planning department annually on forms provided by the department. So this would give the department sort of so we know what's going on, whether it's like the vacation rentals or ag tourism, we have a sense of what's happening. So that they wouldn't necessarily, a small ag tourism operation wouldn't necessarily need to go through the permit process, but they would have to register. So, and it also would allow the department to make, it doesn't require them to go out and do a visit prior. I also added an enforcement provision in here, but also, again, I'm trying to find the balance. Say, if an operation is a minor operation, if they would then have 90 days to go in and seek permission to become a major. I did in terms of Waipio, previously there wasn't any prohibition on there. I went with the middle ground of it's no unless there's a hearing held there and in the area, and then do it. I'm certainly open to whatever others want to say. If we just want to say it's absolutely not permitted there, and then my question is, should we say it's absolutely not permitted also in any place that requires a four-wheel vehicle?
I'm not in agreement with one of them is the times, of course, and a lot of what Corey Hardin was said in her testimony. And most importantly, I think the Waipio issue. I think on the last meeting we had, I stated that I was going to meet with the Waipio Stakeholders Alliance Group, which is a group, several groups that come from that area. And you heard from testimony from Mr. Jim Kane that they came back and said, absolutely not. The reason that I got from them that stood out for me was health and safety, the safety issues, the crossing, and we've discussed this before, and you're aware, Councilmember Willie, of the private property issues, things that happening down in Waipio that has to be resolved before we create chaos and safety issues, more safety issues than they are already dealing with. They're dealing with a lot of safety issues on the road and access. So, I would like to see that section say agricultural tourism, major or minor, shall not be permitted in Waipio Valley, period. And then if you want to say other locations that property is only accessible by four-wheel drive, may be approved by the commission following the public hearing, that's okay. But like we heard previously on protecting our cultural resources also, we all agree that it's so important to protect those cultural resources. Waipio is of that. It's so important to protect that. So I would say you can leave the mention of Waipio, but it shall not be permitted in Waipio Valley, period. And at some time, if some things down the road, years from now, get improved or whatever, whoever is representing or wants to put forward another amendment and now ready for Waipio saying, hey, we're ready, then so be it. But at this time,
I agree.
Thank you so much. Okay, aloha.
And I like definitely some of the amendments that are in this Communication 554.5. I totally agree with Ms. Poindexter, and I think that would be an excellent further amending you could do to this number 14, is to clarify that where four-wheel drive is the only access, that would require an additional layer of scrutiny. I like that idea, and that there shall not be permitted in Waipio Valley, at this time. So I think that would be an excellent suggestion. I thank you for putting in the permitting, because that was my major, I think, contribution to Bill 25 when we discussed it in the previous term with Mr. Kern, and that seemed to be very well accepted by the council and the planning department as a solution to being able to monitor better the activity and make sure people are staying in compliance if we leave that in. I'd like to see you make a couple amendments and maybe look at something Ms. Harden did suggest. I forget now what it was. I totally agreed with, but I can't remember right now what it was, but you may remember. But just to take into consideration a couple more of the suggestions to get this a little bit closer to something we'd like to send to the Planning Commission, I think would be a good idea at this time.
With respect to Waipio, I totally agree. And I'm just wondering if it would make sense to say that it shall not be permitted in Waipio Valley, and instead of period, and instead of or, change the or to and in other locations where property is only accessible by four-wheel drive vehicles. So that way, you totally restrict the Waipio Valley, but you also include, for future purposes, any other locations where accessibility is only by four-wheel drive. Just something for you to consider, because I think it addresses both issues.
The concerns I have, and just off the bat, the insurance concern in exempting District 1 might seem a little showing some favoritism, because you're letting one section go without that requirement, and then all those 2, 3s must.
Okay.
And I think, for me, agricultural tourism should be, it's allowed in our Hawaii revised statutes. The special permit process actually takes care of this issue, and I think it gives us a better and it works well with our Windward and Leeward planning commissions to address these concerns, and then they can come to us through the normal procedures. But not to take away from trying to really help our agricultural tourism in terms of small and bigger operations. We have agricultural tourism now. We have Mauna Loa macadamia nut, we have Hamakua mushrooms, all these great businesses that have grown
Tourism.
out of this
This
area. And I think there's a lot of opportunity
4.5.
for this, but
In your pinkies.
I kind of get in this feeling like we're overkilling it with more legislation and regulation, and perhaps the special use permit process that we already have in effect should address it. I don't know, but thank you, Margaret. I just wanted to voice
Yeah.
that concern.
This would make it so that not everyone has to go for a special use permit. So it's trying to sort of grade it. We can make everybody go for a special use permit, in which case, say you've got over 15 acres, you're into going to the Land Use Commission, spending $10,000 in 3 years. And so we're just trying to make it that even the little guys, what is a farm stand? I mean, these are important questions, and I recognize, I realize. So do a farm stand, do you want to have people go in and spend, or then if it's a small group and they want to try it, they don't know how it's going to work, but they fit in, and they're not adding any business, they're not adding any buildings. In that case, I felt, okay, at least where they're registering, they could do site visits to not require that. But if they add a building, now you're going in for plan approval. So you have different levels. Plan approval means, the director looks at it, okay? And so I sort of went, if you fit these requirements, I mean, I always felt when I did a lot of subdivisions as an attorney, I like to know, I'm on this side of the table, what do I have to do? If I comply with all these things, am I good? And so where can you do that, and under what circumstances, without saying, now you have to go get a special permit, and you get an attorney and you have to do all of this. So I was trying to provide like a middle ground, and as much bureaucracy as we need, but no more than we need. And so it is a balancing. So I do hear you, and I do hear you on the insurance. That was one of my questions, and not do that. And I just want to say the same thing with Waipio. I know Ms. Poindexter was going to have that meeting, so I held off touching that section, I felt, until after she spoke with them. I would have changed it otherwise. I'm really open on this. It's not like I've got an agenda here. I mean, I'm really into the farm stands. He should be able to do that. It's unenclosed. It's open, that we promote this. We promote, tourism and agriculture are two big deals here. But at the same time, I did try to add in things that, try to add things in, but not be absolute. Let's take, for example, the bee people. And if they were to put in a bee operation, which doesn't, say it's on ag land, and say it's down near Mauna Lani Hotel, okay? There's a place there, and they're doing it, and it's how many they're getting, a lot of people. Suddenly it's X. Do we really want to say, no, you can't do that?
Put in enough regulations so that we address people's concerns without over-regulating the minor operations. And I see this number 13 did include activities that would not be permitted without a use permit. And those were some of the things that had come up time and time again that people were afraid that could happen with even a minor tourism operation. So you're making, this number 13 makes dances, overnight accommodations, restaurant facilities, mechanical, amusement rides, dirt bikes, all-terrain vehicles, and other off-road motorized vehicles. Those are not permitted on any ag tourism operation without a use permit. So I think that is what you tried to put in to separate what
Address
would
that.
be a no-problem operation to one that may cause the neighbors some concern. And I don't know if Mr. Arai wants to come up, if anybody has questions for him. I just would want to ask a general question.
Darren Arai with the Planning Department.
Okay, thank you. Mr. Arai, would you, in the process, would you suggest that we further amend this draft to something that we can support more wholeheartedly before we send it off to the Planning Commission? I know Ms. Willie just stated that she wanted to get it referred as soon as possible, but I kind of think that we should do a little more work on it first.
I think that is probably the wisest approach, simply because when a bill is then referred down to the Planning Commission, at least the Commission then knows that some of the preferences and some of the concerns are articulated in the bill, and then they can then respond to those specific proposals. But if it's not really clear where you all sit with the particular components of the bill and then just send it down to the Planning Commission, the Commission will just operate off of what it gets.
Okay. Right,
So
right.
they may not be able to respond to exactly to what you feel is necessary components that needs to be within the bill itself.
Thank you.
So
I know you've probably either been helping with this or thought it through over the last few years that we've been, as a council, trying to codify.
not much actually. You know, I've heard where Councilperson Willie did mention that effort was made by former Councilman Kern and Councilwoman Ford in drafting the bill, but there has not been a lot of dialogue with the department itself. So we've been kind of simply on the peripheral.
Okay.
We may have seen things, but we haven't put a lot of effort in.
Okay. Well, I would like to just suggest that Ms. Willie not only amends with some of the good suggestions that came out of today's discussion, but maybe just check with you. I found that you and other staff in your department are very insightful, and maybe if there's a section that sticks out as a problem, or maybe it hasn't been fully addressed in all the different, like Ms. Willie stated, in the zoning code, there's many areas that would need to be looked at. I would just suggest that we also do that first, because I'd rather support something that I know has been fully vetted before we move it on. This is a pretty complicated issue, and it does have ramifications to neighbors and communities, and so you would be willing to...
Sure, we always remain open to dialogue with the councilors, by all means.
Thank you so much.
You're welcome.
Regarding the vegetable stands, Maui, Kauai do have vegetable stands or produce stands. We see some of ours popping up around. The requirements for vegetable stands, what's the trigger in terms of sales or amounts when they have to go for a special use permit? Because it's allowed on agricultural property.
The state land use law does recognize roadside stands as an outright permitted use, so there are no really defined limits or... So we simply make sure that what's being sold through the roadside stands are associated with agricultural products being grown on the property. So again, I'm not aware of any size limit or hours of operation. It's a permitted use.
Okay, so it is an allowable operation. Okay, I'll leave it that night. If anybody else wants to add, that was just one of my concerns.
Agricultural products grown in Hawaii and value-added products that were produced using agricultural products grown in Hawaii. But I think in terms of any incidentals, like you have cups or hats, that has to be specific to that operation. You're not going and advertising. So just trying to see how both the state law and the county law play together here. I do see, one of the issues is sort of like that Ms. Harding brought up, was like giving notice about, health and safety or not going on other people's property. And I wasn't really sure that's something that I would be doing in an ag tourism bill, or say noise issues. We do have a noise regulation, but how do you deal with that? Should that be done separately? I've got people calling me about roosters and chickens and dogs barking. So I'm just saying, I think just in terms of from a drafting and a law, I think there's some of these issues I'm not trying to disregard, but I'm not sure that putting this in the zoning code is where it should best go. And I will go over some of this with Daryl, but I'm not trying to ignore some of those, but just that I'm not sure. As I said, it took me a while. That's why I handed out the index. I want you all to see, it keeps referring to numbers, go to this district. And I always like, when I refer to a section, I always like to put after it what the title is, so people know what it is, but we don't seem to do that in this county. Or where it says you have to go get a use permit, I wanted to say pursuant to section such and such, but, legal research said, no, we don't do that. And I would like to change all of that, but I think it is complex, and I always look at it as the person walking into the planning office and wants to do something, and how do we accommodate them? I actually did a chart for myself. You'd go here and you can this and that. So thank you for the comments. I don't have anything else, but I will work and meet with Daryl, and so I'd like to maybe postpone this I would just soon do it not till the next meeting, but for like a month from now, if that's okay.
Okay, a month from now is that motion is to postpone this to February 2nd, which is the month from now, on the planning committee, and seconded by Ms. Poindexter. All in
And
favor for the motion?
I just want to mention one, just in terms of discussion on that
Sure, Ms. Williams,
postponement.
go ahead.
Just one point is,
But let's do let's open up for discussion, because this is a postponement, and you got first.
I need 30 seconds, but
Go
I
ahead.
just want to explain, try to do this as quickly as possible, because there are a lot of people right now that are technically out of compliance. We have a lot, and I'm getting calls on that. So we are going to do it another month, but we are trying to move this as quickly as possible. So I just wanted to add that in.
All right, all in favor say aye. Any opposed? We have 9 ayes